Thank you, Mr. Chairman. I'm going to pay attention to your interventions to be brief, and so although I am in support of the intent of amendments under the name of the Mother of the House, and the Right Honourable Member for Orkney and Shetland, the member for Streatham and the member for Walthamstow, I'm going to focus solely on Amendment 13. There is no doubt there is a need for a bill like this. The infiltrating of terrorist gangs and going undercover as an informant is a dangerous and risky work and often requires breaking of the law. And this bill enables authorisation of those breaches of the law. But my Amendment 13, in my name and a number of others, explicitly exempts the most serious crimes of murder, torture, rape and others from powers in the bill. And the government argues that this is not necessary because the Human Rights Act already limits its actions. So the question before the House today is, do we believe that? Do we think that is sufficient? Back in the early 1990s, I was one of the ministers who took through the Secret Intelligence Service Act through the House. In that Act, there is now a clause, or now Section 7, which enabled MI6 officers abroad to commit crimes in the interests of the state. Inevitably, in the tabloid press, it became known as the James Bond clause, but that is actually precisely what it was not. It was not a license to kill. It was a license to bribe, burgle, blackmail, bug, but it was not a license to kill. Nevertheless, within a decade, Clause 7 was being used to authorise rendition, torture, mass invasion of people's privacy, innocent people's privacy, crimes which were never countenanced when the Act was put in place. I know, I did all the work behind it. It should be understood that the authorisation of those crimes, often within the United Kingdom, occurred after the Human Rights Act had been passed. Indeed, while the ink was still wet on its pages in some cases. And it provided precisely zero protection. Neither did the European Convention on Human Rights, the International Convention on Torture, the 1949 Geneva Convention, to all of which we are signatories, and some of which are absolutely binding in law. So no protection was provided by these whatsoever. So that's why I want us to vote for. Yes, of course we do.
I'm connected to my right honourable friend Given Way, and he has huge experience in this area, I know, both legislatively and previously professionally. He is an expert. But can I just ask him, if a checklist, as he suggests, is put on the face of this bill, is that not also a checklist for terrorist gang leaders to prove a rite of passage and loyalty to somebody who might be working covertly on behalf of our national security interests?
Well, I'll say a couple of things. Firstly, if the gangster is smart enough to read the Act, he's smart enough to read the Human Rights Act. That's the first thing. Right? The second thing is, in my clause, in my Article 13, I put in specifically a reference to the DPP, so that if my honourable friend is in such a circumstance and he has to do something violent to prevent himself being killed, that is an exoneration for the DPP. So it specifically allows that clouding, if you like, of the judgment. But on that and indeed, sorry, somebody. I would draw his attention to the intervention in the Times last week. I was going to mention it later, but I'll mention it now. The intervention in the Times last week by one of the best directors of public prosecutions of modern times, Lord Ken MacDonald. He's not my politics, but he's very, very experienced, and he knows all about these things, and he described this as soprano-watching judgments, or soprano-watching logic. And I'm afraid I agree with him. And I'll come back and illustrate why in a second. Now, officers, as my honourable friend says, in the intelligence and the policing agencies can face huge pressure to authorise improper criminal activity, particularly when the demands on the agencies themselves become enormous. We saw this after 9/11, when after the dodgy dossier we had all the rendition issues occur. The people doing that, I always said in those days, we must not prosecute these intelligence agencies, or the individuals, because they were trying to prevent a 9/11 happening at Canary Wharf. But it was still wrong. And these morally indefensible actions by the state and their agents occur at the darkest times in our history. We must remember that. And we must write our laws to cope with the darkest times in our history, which is what we're trying to do here today. Now, I'm going to pick an example which the honourable members in Northern Ireland will say cannot happen now, and they're right. But I want to use it to illustrate. For example, there's the murder of the prominent Belfast lawyer, Pat Finucane, who in 1989 was shot 14 times as he sat down for Sunday dinner with his wife and 3 children. It emerged that the loyalist groups responsible for the murder of Finucane had been infiltrated by UK intelligence operatives. The 2012 review into the killing found collusion by the UK state in identifying, targeting and murdering Mr Finucane. It also found the state supplied a weapon and facilitated its disappearance following the murder. The inquiry also found that senior army officers deliberately lied to criminal investigators, and the Royal Ulster Constabulary Special Branch were responsible for seriously obstructing the investigation. As a result, David Cameron, as Prime Minister, apologised for the actions of the British state. Now, the point about this is it's not the only violation that occurred during the Troubles, and we all know the terrible pressures that applied to everybody, even people in this House, during that time. But that's what we have to accommodate. From rendition to murder, not at the behest of the state, but at the acquiescence of the state. I give way.
On this point about rendition, he will recall the Intelligence and Security Commission, when considering the Belhaj and Bujahar cases, said that effectively what had been done there was that our services had outsourced work that they were not allowed to do in law themselves. Doesn't that alone indicate that these services require proper independent scrutiny? They should not be left to mark their own homework.
Right, and of course, one of the things we shouldn't forget in all of this was that clause that was used required ministerial approval, not approval by an officer in the pressure of the, as it were, almost the battlefield sometimes, but a minister in Whitehall approved it, and it still happened. Now, there were 2 sets of inquiries. One by Lord Stevens, who, again, I say to my honourable friend, is nobody's softy in this. He did 2 inquiries into these problems, and by Sir Desmond de Silva. And de Silva concluded that the problems required some recognised limits as to the extent which agents should become involved in criminal enterprises, and a rigorous regulatory framework to prevent abuses. A rigorous regulatory framework to prevent abuses, not a woolly reference to the Human Rights Act, but a rigorous thing. I give way.
I'm very glad that my right honourable friend is making a very powerful speech. References as well as Lord Stevens of Kirk Walpington, and also the late Sir Desmond de Silva, who some of us knew personally, and of course came at that from long experience at the criminal bar, and also the experience of being a prosecutor in the International War Crimes Tribunals. Yeah. Certainly, again, he was no soft touch. He was used to going after bad people, but believed it was necessary to do so within proper constraints.
Yeah. And my honourable friend's absolutely right, and he actually tells me why now that Sir Desmond did something else in his report. He quoted Lord Atkin, who in a landmark case during World War II said, and I quote, "Amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace." And I'm afraid this bill, necessary as it is, does not meet that test. And that's the problem in front of us.
My right honourable friend give way briefly.
Yeah, all right, the chairman will kill me, but never mind. Wait.
Right honourable friend giving away. He quite rightly mentions the Pat Finucane case, which correctly David Cameron, then Prime Minister, apologised for. But does he also recognise that since then the security services have more judicial oversight than ever before? Then we didn't have the Investigatory Powers Commissioner, and even the powers of this House to have more oversight of the security services has increased. There's been a marked difference. Times have changed.
Well, they've changed a bit. One of the things that the 94 Act created was the Intelligence and Security Committee. And the Intelligence and Security Committee tried to look into rendition and torture just recently, under its previous chairman. and it was refused access to 15 cases. So much so that I am now suing the government on exactly this to force them to have a proper judge-led tribunal. So even now, it's not good enough. Not after 20 years, it's still not good enough. And the trouble is that others do it better. America and Canada learnt the hard way that the need to include specific limits in the crimes that agents can commit. In these countries, both informants and their handlers were involved in carrying out numerous cases of racketeering and murder, and they were found out, and since, both countries have set clear limits. And just as an aside here, in terms of the overall public interest of this, we all want our agencies to be able to work. But what the FBI investigation found was actually the lack of limits, the woolliness of the controls, led to more crimes, not less. The so-called soprano effect worked in reverse in terms of protecting the national interest or the public interest. So the bill puts no express limits on the crimes agencies can authorise, not murder, not torture, not rape. And it claims the Human Rights Act provides this safeguard. But their own submissions in court, already referred to by the lady for the SNP earlier, and indeed the member for Orkney and Chetland, I think, also earlier, showed that their own lawyers don't believe it. And I would say to the House, actually, if they've got a quiet time travelling back to the constituencies, they should read the Investigatory Powers Tribunal findings on the behaviour of the agencies. It's almost a James Bond novel in its own right. The scathing descriptions of the operations are worth reading. So, the amendment in my name, Amendment 13, addresses the most egregious elements of the bill. It puts hard limits on the extent of criminal conduct that can be authorised by officers, specifically prohibits murder, torture, serious bodily harm, sexual assault and other heinous crimes. Crucially, Amendment 13 explicitly permits prosecutors to drop a case in a situation where an agent is truly forced to participate in a serious crime and a decision not to prosecute is in the public interest. There is a real need for legislation in this area, a real need, but the bill as it stands carries real risks of serious injustice. My amendments will give the intelligence services the protections they need, but stop short of giving them the carte blanche authorisation to carry out the heinous crimes in the names of the state that have happened too often in the past.